I keep hearing that there are a lot of ways to avoid probate. What are the most common or the top 3 ways to avoid probate? Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. You need to avoid probate. You should avoid probate. Why do people want to avoid probate all the time? Because it will save your loved ones precious time and valuable money. Let's start with what's considered the most comprehensive method to avoid probate, and that is a properly funded revocable living trust. With a revocable living trust, you transfer the ownership of your assets into a trust during your lifetime. Trust documents provide privacy for your family because trust documents are not public record like wills are. When you set up a revocable living trust, you are the trustee of that trust and you maintain control over all of your assets. Your named successor trustee settles your estate, distributes your assets to your beneficiaries based on the instructions in your trust, and no court involvement would be necessary unless there was a dispute among the beneficiaries. No court involvement saves the estate tens of thousands of dollars. The second top method to avoid a probate is beneficiary designations. Do you remember when you opened your first savings account? The banker asked you, who did you want to name as a beneficiary in case you had an unexpected death? This is an example of a payable on death account. There are also transfer upon death accounts, such as securities, stocks, bonds, and brokerage accounts. There are also transfer upon death deeds, which apply to real property. When you pass, the title automatically transfers to the name recipient. Life insurance policies, retirement accounts such as IRAs and 401ks use beneficiary designations in order to transfer your assets to your beneficiaries. The third most common way to avoid a probate is by holding title in joint ownership with the right of survivorship. Basically, you hold title with others, and the last surviving joint tenant owns the property by himself or herself. And eventually, when that person dies, that property will have to be probated unless that property had been placed in a revocable living trust. There is joint tenancy with the right of survivorship. This applies to individuals. They own equal shares. There is community property with the right of survivorship. This applies to married couples or registered domestic partners. And this method of holding title offers major tax benefits. Question of the day: which one of these methods of avoiding probate were you not familiar with? Let us know in the comments below. It is always a good idea to consult an experienced professional estate planning attorney before determining which one of these methods is best for you and your family. I'm Darrell Williams. This is Win-Win Realtors TV. If you know someone that's dealing with a probate procedure and they have questions in reference to the estate real estate, share this video with them. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need an attorney, please contact one. If you need an estate planning attorney here in the Southern California area, feel free to reach out to me for a referral.